Hello, everyone, and welcome to today's Lunch and Learn, which is being presented by Jared Marr from Grace Lawyers. So, Jared has quite a lot of experience when it comes to strata law, and he's going to talk about committee memberships and decision making. And it is that time of the year where there are lots of AGMs going on, so all very relevant. So before we start, I'd like to acknowledge the traditional owners and custodians of the lands from where we're joining this meeting. So here in Brisbane, that's the Yugara and Turrbal people, and from where you are, it could be someone else. I'd like to acknowledge their elders past, present and emerging. So over to you, Jared.
Thanks very much, Wendy, for that introduction, and hello, members. So today I'm going to be talking about committee membership and decision-making by committees. So there's obviously a lot of stuff to get through, so I'll go through the slides. I'm conscious that we've only got half an hour allocated time, so there will be probably about 5, maybe 10 minutes for questions at the end. So feel free to add them to the chat and Wendy will have a look at those and check them for relevance, and then we'll go through some answers to those questions, hopefully at the end. So diving right into it. So the process of nominations for committee members. The process starts by a member nominating another person who's entitled to be on the committee. Now, the time frame for the invitation by the secretary is between 3 and 6 weeks before the end of the body corporate's financial year. And then a member who wishes to nominate somebody must return that nomination to the secretary before the end of the body corporate's financial year. Be aware too that there's a requirement for the secretary to provide written notice of receipt of a nomination as soon as practicable to the person who made the nomination. The number of nominations that can be made. So each owner may nominate one voting member. That's our starting point there. Now, where there's multiple lot ownership, so where one owner owns 2 or more lots, if there's fewer than 7 lots in the scheme, that member may nominate up to 2 persons to be voting members of the committee. In circumstances where someone owns 3 or more lots, then that person may nominate up to 3 voting members, provided that there's more than 7 lots in that scheme. So persons that can be nominated, owners, obviously, a immediate family member, so that extends to a spouse, a child, a parent, or a sibling. Note also that in relation to children and parents, it includes stepchildren and step-parents as well. A corporate owner nominee can be nominated, and also a person acting under a power of attorney for an owner. So what restrictions are there in relation to nominations and holding voting positions on the committee? So obviously we've got the restrictions on body corporate managers, service contractors or letting agents. That extends to their associates as well. I think it's still section 312 of the Act that puts in a definition of associates, which is very, very broad. So have a look at that section if in doubt, but you'll be able to see that it extends well beyond just a director or shareholder of a caretaking entity, including anyone that would be accustomed to act on the instructions of that particular person. So a very broad definition, and also the definition also says that where a series of relationships can be traced between those types of people, then that is also captured under the definition of an associate. So very broad, and so be conscious when nominations are made that there's not one of those existing relationships that would be captured there. A person who conducts a letting agent business. So this is someone that doesn't necessarily have a letting agreement with the body corporate, but nonetheless, under the Property Stock and Business Agents legislation, conducts a letting business for 1 or more lots in the scheme. And also a person who owes a body corporate debt. Now that applies at the time that the member or at the time of the election. It also applies to the person making the nomination. So if the person nominating owes a body corporate debt, either at the time that the nomination is made or at the meeting, then anyone that they nominate is unable to hold a position, their nomination is invalid. And also, obviously, if the person themselves owes a body corporate debt at the time of the meeting. So the procedure, which we should probably mostly be familiar with, conducted as the last item of business at each annual general meeting of the body corporate. There's a bit of a difference here between the standard and accommodation modules, which are the two that we generally deal with. So in the standard module, the default position in the legislation is that it's a secret ballot unless there's an ordinary resolution passed to change that. Under the accommodation module, it's the reverse. It's an open ballot unless there's an ordinary resolution to make it secret ballot. There is another provision in the modules which allow any of the procedures for the election of committee members to be altered by a special resolution. So there's no limit or restrictions on what could change, but if there's a special resolution passed to adopt some other procedure, as long as that procedure is, and the legislation uses these words, fair and reasonable, then that will be able to be altered by a special resolution. The executive positions are filled first, so chairperson, secretary, treasurer, followed by the ordinary member positions. And obviously, if there's insufficient numbers in terms of a particular position, if there's only one candidate for a particular executive position, or if there's not more than the maximum number of voting members, then there won't be a ballot required for any particular position. Those members that have nominated will be elected unopposed. Another little quirk between the modules, the standard and the accommodation, the standard module has this clause which says that the candidates must be listed in alphabetical order by surname. There's no similar restriction in the accommodation module, so it could be any particular order that the committee decide. I was involved in an adjudication case where someone tried to argue that by implication, because of the reference in the standard module to alphabetical order, that should also deem that a decision by the committee in the accommodation module to list them in some other manner other than alphabetical order is unreasonable. That application was dismissed. So as long as the committee aren't sort of trying to manipulate the outcome, and I don't know how you would establish that, if they just decide what order to put the candidates in, then there's no restriction there under the accommodation module. So the composition of the committee, minimum of 3 voting members and a maximum of 7. We've got the 3 executive positions there, and also the ordinary voting members, up to 4 of those. Also, automatically, without having to conduct an election, those 2 parties are automatic non-voting members, body corporate managers, or a caretaking service contractor. So that's a service contractor that also holds letting rights for the scheme, a letting agreement with the body corporate. If an executive position is not filled or the maximum number of voting members is not achieved, then nominations for those vacant positions can be invited from the floor of the meeting. If there's not at least 3 voting members elected at the meeting, or one of the executive positions is not filled, even after inviting nominations from the floor, then there's a requirement to hold an EGM within 2 months to conduct or to fill those vacancies. If there's a tie between 2 or more candidates, then the elected member is decided by a game of chance. And that could be anything. That could be drawing straws or flipping a coin, so whatever the meeting decides. So how long does a committee member hold their position, and how does it usually come to an end? So it continues until another member is chosen for the same position. So just be aware of that in terms of the holding over of committee positions at an AGM. So if someone's not elected to replace a particular member because there's no nominations, then that person's position remains in force. It doesn't vacate at the AGM. And then there's a number of other reasons why a person's position may become vacant. So we've got the list of matters there. Person dies, becomes ineligible. So most commonly we see a person sells their lot during their tenure. A person by written notice to the chairperson or secretary resigns. If they're not present at 2 consecutive committee meetings, there is provision in that section for the committee to excuse that if they decide by a majority that that person can be excused from that requirement. If the person's convicted of an indictable offence, that doesn't need to involve any fraud or dishonesty. So be aware that even though those references are often used in relation to caretakers, that it could be any type of indictable offence. Also be aware that even though the legislation uses the word convicted, a conviction doesn't have to be recorded. So probably it's better to think of if there's a finding of guilt in relation to an indictable offence, then that will vacate the person's position. Obviously, a person can also be removed by ordinary resolution, including the code contravention process, which is quite long-winded and would take at least 2 general meetings to finalise. The committee's obviously got no power to remove one of its members. So when a vacancy arises, how do we fill it? First, it's important to understand what a quorum of committee members is. So I can see the list there. So if there's 3 or 4 voting members, then a quorum is 2. So it's at least half of the committee voting members. If there's 5 or 6 voting members, then, sorry, if there's 5 or 6 members, then it will be at least 3 voting members to form a quorum. And if there's 7 voting members, then a quorum is 4. So if the number of committee members has not fallen below a quorum, then the committee at committee level can appoint a person that's otherwise eligible to hold a position to fill their place. If the number has fallen below a quorum, then the committee must call an EGM to fill the vacancies within 1 month. Powers of a committee. So there's a general provision under section 100 of the Act that a decision of the committee is a decision of the body corporate, unless it's a restricted issue or above the committee's spending limit. So the spending limit of the committee is set by ordinary resolution. If there's no amount set by ordinary resolution, then the default is $200 times the number of lots in the scheme. So what are the restricted issues that a committee can't decide? Raising contributions, changing rights, privileges or obligations of owners. Now that's a bit of a catch-all provision which a lot of owners rely on to try and invalidate decisions of committees. So you see a lot of adjudication applications around that second bullet point because it's quite broad. Ultimately, the adjudicators have tended to exercise a degree of discretion. You could argue that nearly every decision would affect the rights, privileges or obligations of owners, but it's got to meet a certain threshold for an adjudicator to find in favour of an applicant. If the issue requires a resolution at a general meeting, so if the legislation says that it requires an ordinary resolution, majority resolution, special resolution or resolution without dissent, it has to be decided at a general meeting. There's a restriction on the committee starting proceedings generally. There's some exceptions to that, including recovery of levies and debts from lot owners. Also notably, adjudication applications are not a restricted issue, so the committee can commence those. Also enforcing adjudicator orders is not a restricted issue for the committee. An appeal of an adjudicator's order is a restricted issue. And also to pay allowances to committee members is a restricted issue which the committee can't decide, except again, there's a couple of limited circumstances in which there's some exceptions. One is if it's been previously approved at a general meeting of the body corporate, or for travel expenses of up to $50 on each occasion, up to $300 per annum, for a committee member to travel and attend committee meetings. So the meetings, so we've got the two types of meetings, the usual meetings that are called by the secretary or chairperson in the secretary's absence. They must be held within 21 days after a majority of committee members request the calling of the meeting. And then at least 7 days notice must be given of that particular meeting. Our VOCM meetings or voting outside committee meetings, so notice doesn't need to be given to all members, although should if it's practical to do so. If it's an emergency, people could return their votes by oral, by telephone. It doesn't necessarily need to be in writing, but obviously, if that's possible, then votes should be at least through some written communication, so there's a record and evidence of it. But it's not absolutely necessary if there's an emergency. And the motion is resolved as soon as there's enough votes for the motion to carry, or if the motion is lost. And there's a 21-day period for members to exercise their votes on a VOCM. So I wanted to talk a little bit too about the committee exercising their discretion, and this is really the issue of reasonableness, which applies not only to body corporates at a general meeting, but also committees. And I think it's probably more important in a committee context, because obviously it's up to owners how the body corporate votes at a general meeting, whereas the committee will be subject to a lot of applications to the commissioner if they're not exercising reasonable exercise of discretion and judgment at committee meetings. So I think it's quite important. So I wanted to touch on that briefly as well. The Aurora Tower was a good recent case about 5 or 6 years ago. I provided a very good summary, in my view, of how an adjudicator looks at the issue of reasonableness in terms of body corporate, including committee decisions. So the adjudicator in that case said it's not their role to substitute the opinion, standards, judgment, or discretion for those of the body corporate or its committee, nor to balance the pros and cons of a particular proposal. Reasonableness, rather, is not measured by an assessment of what the adjudicator considers is the correct or best decision. The assessment takes place by the adjudicator assessing if a notionally reasonable committee faced with the same issue could, not necessarily would have, honestly and rationally reached the same conclusion after a proper consideration of all of the available material. So we can see there, we immediately get some sort of fundamental principles around this issue of reasonableness from that case and previous cases that have looked at the issue of reasonableness. So note it's possible for two different committees to arrive at two different outcomes, both of which are reasonable and not subject to being overturned by an adjudicator. So that the applicant has quite a high bar in terms of an application to the Commissioner's Office to have an adjudicator overturn a body corporate decision. They have the burden of proof to establish that the decision was unreasonable. The starting position is that all decisions are reasonable. So they have the onus, and they will only be successful in circumstances where the only inference from all of the available material and evidence is that the decision was objectively unreasonable. So again, two different committees can reach different conclusions, and both can be reasonable. There's no correct or best answer, in the words of the adjudicator. Another decision, which is a fair bit older, but I think also provided a pretty good summary of the issue of reasonableness. This was a member who, and a specialist adjudicator who subsequently went on to sit on the district court, now retired, member Dorney, King's Counsel, and it provides a very good summary again of the way that an adjudicator must assess the issue of reasonableness in terms of body corporate decision making. So the specialist adjudicator, as he was at the time, said there is no obligation on the body corporate to advance specific reasons for its decision not to approve a particular motion at the time it makes its decision. The body corporate is entitled to rely upon reasons in the adjudication proceedings that weren't expressed at the time of its decision. And it's not an adjudicator's role to assess whether a decision is right or justifiable. So similar but different wording to the adjudicator in Aurora. And a decision will be reasonable if there are reasons for it which can be justified at some level, and those reasons are genuine and not fanciful. So we get a bit of a summary of the test for reasonableness. So it doesn't have to be the correct, best, preferable, or right decision. That's looking at it in the wrong context. A decision will be upheld as reasonable as long as there's some genuine and not a purely hypothetical or fanciful reason or reasons for the decision. There's no requirement for a committee to specify or detail its reasons for a decision in order for it to be reasonable. That said, and I'll come to some tips in terms of decision making in a moment, but that doesn't mean that it's a good idea not to give reasons for a particular decision, particularly if you're voting down a particular lot owner's motion. So here's my tips in terms of how to guide your committees in making good decisions which will stand up to scrutiny if an application is made to an adjudicator. But more so than that, hopefully following some of these would actually mitigate or prevent or minimise the number of applications that the committee are being faced with that have to be responded to. So follow a comprehensive process to gather all required information in relation to the motion put forward. Engage with the proponent of the motion rather than just burying your head in the sand. If there's an element of the person's motion which is not clear, then request that they clarify it before the committee vote on it. Raise any concerns with the proposal and provide an opportunity for the proponent to rectify them. Provide alternative options and solutions if there's an issue, rather than just blanket refusals or denials. If necessary, pass a resolution subject to conditions. So on this point, whilst an owner has a right to have their motion considered by the committee in the exact form in which it's submitted, there's nothing preventing a committee from passing their own resolution, which approves something subject to particular conditions that the committee want imposed as part of their approval. Doing that might make the person who receives the conditional approval think twice about lodging an application with the Commissioner's office if they can live with the conditions that are being imposed. And as mentioned before, if refusing a motion, even though the committee is not required to, you're better off giving reasons and listing the factors that the committee took into account in reaching its conclusion. So hopefully some of those tips are useful. Should have a little bit of time for some questions. I'll jump into the chat and see if I can answer any questions that people have. Don't have any questions, but I'm not sure if you've seen any come through. I can't see any in the chat, Wendy. So hopefully
no, there's no questions in the chat. Are you able to give us an example of what a reasonable motion, or what an acceptable motion would be, and what a maybe unreasonable motion would be, or an unclear motion that's put forward?
Yeah, so regardless of whether it's a committee motion being decided by the committee or an owner motion being decided by the committee, it needs to be a concrete and firm proposal to do something. Now that might be simply to go out and obtain quotes for something. There's nothing inherently unlawful with a motion which proposes that the committee go and do certain things. The committee has to then follow through and do what the motion requires. So it doesn't, I guess, need to result in a final outcome. It doesn't have to be, here are the quotes, and the motion is to consider the approval of one of the quotes. It could just be to obtain quotes, but it has to be something concrete. So if something's too loose in its language, it's sort of is not very clear in what it's directing the committee to do, that would be a motion which properly it can be ruled out of order, or isn't, doesn't have to be, or should be voted down by the committee, because it's not clear what it's actually asking the committee to do.
So it might be something like putting a motion to repaint the fence, which could be kind of a little bit unclear which part of the fence, what color.
Yeah, I think that sort of
yeah
that motion would be invalid, in the sense that it wants the committee to actually undertake the works, but it hasn't submitted quotations with the proposal. If it said, on the other hand, that the committee obtain 2 quotations to paint the fence, then that would be valid, and the committee would should follow through and obtain those quotations. Doesn't mean that they have to approve one. They've simply got the quotations, which could then be considered at another meeting.
But it should probably say whether it's the whole fence, part of the fence, or because there'd be a bit of difference in price, I should imagine. But
that's right. Yeah.
And if you're going to go out and get a quote, it needs to be clear what it is that you're wanting to do too. So
that's right. Yeah, the subject matter of the motion also has to be clear. There's obviously lots of fences in a lot of community title schemes, and not all of them will be, the responsibility of the body corporate. There may be fences that sit on the boundary of scheme land and other property, which is subject to the neighbourhood disputes and dividing fences legislation, which then would require the consent of the adjoining owner. So if the motion hasn't properly thought through those considerations, then there's going to be some issues, and the committee should rightly vote those motions down, and also give reasons to try and prevent or mitigate the risk of an application for an adjudicator to make orders.
Or at least get clarification on it, so it's absolutely kind of clear as to what it is that they're agreeing to.
Absolutely. Right to the owner. It's better to engage with them than to simply take the motion if there's an issue with it and say, well, we can just vote that down. And you might be you might be ultimately proven right by an adjudicator, but that doesn't mean that you won't have to take the time and expense of responding to the application. So I think follow those tips. Engagement is always better than no engagement, even if you have a difficult owner that is difficult to deal with.
And so therefore, would it be worth, if a motion is decided upon, is it sort of worth then recording in the minutes of the meeting the reasons either for or against that motion, so that it's sort of on record and it's something that can be referred to if it does go further?
Yeah, I think in particular in circumstances where you haven't engaged with the submitter of the motion and haven't outlined your concerns with the motion before the meeting, I think then it's important to make sure that that some reasons are included, particularly if the committee are of the view that this owner is going to take it to the commissioner's office. List the reasons, but make sure that they're not an exhaustive list of reasons. I mean, so it'd be better to have some wording which says, without limitation or something to that effect, the reasons for voting down the motion were, A, B, and C.
Lack of clarity over what the request was for, something like that.
Exactly.
So that if you've got a Y recorded somewhere, that gets you out of a fair bit of trouble later on. So
yeah, absolutely.
All right. Okay, so we don't have any questions in the chat. So thanks very much, Jared, for the session on committees and resolutions and nominations. It's all a bit of a complicated mix, really, isn't it?
It's a lot to squeeze into sort of half an hour. So hopefully,
half an hour.
Hopefully, the members got a bit out of that.
Yeah. So thank you very much for that. We have recorded the session, which we'll probably upload into YouTube as well, so it can be watched later, if that's okay with you. And thank you to all of our members who've attended today.
Thanks, Wendy. Thanks, everyone.
Thank you.